Further hearing in the appeals, Miller and O'Brien and Ministry of Justice, and Walker and Innospec.
Yes, Mr. Chairman.
My Lady, my Lords, by the end of my submissions yesterday, I had taken you to the judgment of the Court of Justice in Maruco, which you have in Authorities Bundle 1, Tab 7, starting at MS 251. I had pointed out that the service to which Mr. Maruco's life partner's pension related was either entirely or almost entirely complete by December 2003, the transposition deadline for the Framework Directive. And one gets that from paragraph 20 of the Advocate General's opinion at MS 260. Before I leave that case, can I deal briefly with what Mr. Kavanagh and Mr. Coppell say about it? Now, my Lady, Lords, Mr. Kavanagh's line yesterday was that this case tells us nothing, one way or the other, about whether a claim can be brought for pension referable to periods of service prior to 2003, notwithstanding that the service in question was all or almost all prior to 2003. That issue was, Mr. Kavanagh suggests, simply overlooked by the German court, so the question was not asked, and as a result, the issue was not addressed by either the Advocate General or the Court of Justice. Can I ask the Court just to look, by way of answer to that point, at paragraph 32 of the Court's judgment on MS 283.
I'm sorry, somebody sneezed. What's the page reference?
283.
283.
Yes.
Thank you.
Paragraph 32. And this is where the Court of Justice records the referring court's reason for referring question 5. And if one just looks at the second sentence of 32, the referring court states that the provisions of national law at issue in the main proceedings fall under Article 141 EC, formerly Article 119 of the EC Treaty, and that the direct effect of that article can be relied on only in respect of benefits payable for periods of employment subsequent to 17 May 1990. The referring court refers in that regard to Collarol. So precisely the case law that my learned friend Mr. Kavanagh relies on in this case. So what do we draw from that? Well, we draw that the referring court had quite clearly in mind the possibility that an EU claim could only be brought in respect of pension referable to periods of service before 1990. They clearly had that possibility in mind. If one then turns over the page to MS 285 and looks at 44 and 45 in the judgment, now this is part of the judgment dealing with questions that we are not directly concerned with, because these are the questions concerned with whether or not the benefit in question was pay within the meaning of the directive so as to come within the material scope of the directive at all. But you will see from paragraph 44 that there is an express reference to 10 over in paragraph 44, and in paragraph 45 an express reference to both 10 over and Collarol. Now Mr. Kavanagh says that shows the court couldn't possibly have been intending to depart from those cases. In fact, what it shows is that it did not regard the success of Mr. Maruco's claim, a claim for access on non-discriminatory terms to a pension benefit to which he was undoubtedly entitled, was and is undoubtedly entitled, as a departure from 10 over or Collarol. So far from assisting Mr. Kavanagh and Mr. Coppell, the express reference to the cases that he relies on assists me. And if one then looks at paragraph 74, which is a couple of pages later on, at page 289, and the summary, the court's own summary of the question it had been asked, just look at the words it uses to summarise the question it had been asked. By its fifth question, the referring court seeks to know whether, in the event that the directive precludes legislation such as that in the main proceedings, entitlement to the survivor's benefit at issue in the main proceedings must be restricted in time, and in particular to periods subsequent to 17th of May on the basis of the case law in Barber. So that's the summary. Note, the question that they thought they had been asked was not just whether the effect of the judgment should be limited, but whether entitlement to survivor's pension should be limited. Now, on Mr. Kavanagh's case, the correct answer to that question was yes, entitlement to a survivor's pension should be limited, and much more severely limited than the referring court was suggesting, because it should be limited by ruling out not just pension referable to service before 1990, but all pension referable to service before 2003. Now, on Mr. Kavanagh's hypothesis, the reason the court didn't say this is because it had been asked a question about the effect of the Barber case law, whereas this much more severe limitation that he argues for arises as a consequence of another body of case law, a body of case law which Mr. Kavanagh spent much of yesterday trying to convince you was in fact very similar to the Barber case law, draws on the same considerations of legitimate expectations and so forth, and uses the same language. Well, we say with respect that this makes no sense. The only plausible reading of the judgment and the answer that the court gave to the question that it understood it had been asked, see paragraph 79, is that EU law gave Mr. Maruco a discrimination claim even in respect of service prior to 1990. And if it gave Mr. Maruco a discrimination claim even in respect of service prior to 1990, then it plainly gave him a discrimination claim in respect of service prior to 2003. Now, Mr. Koppel, perhaps recognising this, tries to distinguish Maruco. At paragraph 52 of his case, MS 3026, he says that the pension scheme in issue in Maruco was not a standard defined benefit scheme like the Innospec scheme. Well, we say, with respect, that completely misses the point, because the precise kind of pension scheme at issue in Maruco doesn't matter as long as it was one to which the Framework Directive applied. And that, as your Ladyship and your Lordships have seen, was one of the questions referred. So questions 1 and 2 in Maruco were dealing with the question, was the benefit at issue here one that fell within the material scope of the Framework Directive? Did it come within pay in the meaning of the directive? And the answer was actually given, it was considered in some detail by the court at paragraphs 48 to 55 on MS 285. So they considered the particular characteristics of the pension scheme at issue in Maruco's case. They found that the benefits payable under a pension scheme constitute pay within the meaning of the Framework Directive if, 1, they concern a particular category of workers, 2, they are directly related to the period of service, and 3, their amount is calculated by reference to, and this phrase is then used, the last salary. And if you look between 48 and 55, the court goes through the facts of the pension scheme at issue in Mr. Maruco's case and finds that the pension scheme in question satisfied all of those three characteristics and therefore was a pension scheme within the material scope of the directive. Now that phrase, just for your note, I'm not going to take you to it now, but just for your note, that phrase calculated by reference to last salary is in fact, as pointed out by the Advocate General in Römer's case, we'll see in a moment, must have been a slight slip of the pen, because in fact the pension scheme at issue in Mr. Maruco's case appears to have been calculated by reference to average salary rather than final salary. And one can see that actually by looking at the Advocate General's opinion, footnote 72, page 269. That footnote tells us that the German referring court states that the contribution... I'm sorry.
Which footnote is it?
72.
72.
The German referring court states that the contributions amount to 9% of the salary, reaching 16% where the insured is exempt from contributing to the statutory scheme. So the contributions were set at a percentage of salary, and therefore the quantum was a proportion of average salary, not final salary. That didn't matter.
It may not matter, but does it follow?
Doesn't follow.
It may not matter, but why does that follow?
Well,
Most final salary schemes, the contributions are based on a percentage of your salary for the time being.
Well, when one looks at the discussion of the court, which I've just shown you between 44 and 55, and the questions that they asked at that point, what one can see there is that the scheme was based on service. The contributions were set by reference to a percentage of salary, and see paragraph 71 of the Advocate General's opinion on page 270. The amount of pension is calculated on the basis of the amount of contributions. So I think that's the answer to the question that my lords put to me. That's the missing link, for which I'm grateful to Mr. Schaefer. With that link, it does follow. So this was, on any view, a defined benefits scheme. It constituted pay within the meaning of the Framework Directive, just like this scheme, Innospec's scheme, does. And so there are no relevant differences in that regard between the scheme at issue in Maruco's case and the scheme at issue in this case.
Can you just, going back to the fifth question on page 289,
Yes.
I have some difficulty in understanding the relationship between paragraph 78, where the court is saying there's no problem with financial balance,
Yes.
and what the Commissioner is saying at paragraph 76F, where the Commission seems to be saying there's no problem with financial balance because we only have to go back to January 2005.
Yes. Now, of course, there are two questions of retrospectivity.
Yes.
The retrospectivity is raised in two senses here, and those two senses are disaggregated when we see Römer's case. There are two separate questions. One, can you go back to claim pension which was due to you from 2003 onwards, or before 2003 onwards? And a second question, can you go back to claim pension due in respect of periods of service prior to that? And when we come to see Römer's case, those two questions are very clearly separated. In this case, of course, there was no need to separate them because Mr. Maruco died in 2005. So there was no question of claiming survivor's pension prior to that, because it wouldn't have been payable prior to his death. Mr. Romer's case is different, because in Mr. Romer's case there are two separate retrospectivity issues, and we'll see that those two issues are dealt with very differently. And essentially the answer that's been given in Mr. Romer's case is, no, you can't claim pension which is due prior to the coming into force or the transposition deadline of the Framework Directive, but you can claim pension referable to service before that date.
I mean, I understand that point. What I don't understand is the Commission, so the Commission and the Court are talking about different things, aren't they?
Well, the Commission may be saying that because you're not going to face backdated claims before the point at which discrimination became unlawful, you're not going to face claims for pension due prior to the point at which discrimination became unlawful. You're not going to be dealing, as you might be in a Barber-type case, with much older cases.
That wasn't the problem in Barber.
Well, I accept that there are two differences. One is that in Barber, you're talking about claims which are brought by reference to service prior to the date. And so one difference is that actually there just are not any financial difficulties which are shown on the evidence. And we'll come to see when we look at the evidence in this case, there simply are not any evidenced financial difficulties to which success in this claim gives rise. The sums involved are, well, they look like large sums in raw terms, but in pension terms, they are tiny. So that there simply is no evidence, whether from Innospec or from the government, that allowing this claim will give rise to difficulties either for Innospec's fund or for funds in general. None at all. And that actually is what the court is saying here at 79. They're saying this is just not a case where the evidence reaches the threshold for a Barber-type limitation. Can I show your ladyship and your lordships the what happened when this matter returned to the German court? Because we've been looking obviously at what the Court of Justice had to say about this, but the matter was remitted to the German court, and we have the German court's judgment in the core volume MS 2918 to 2922.
Mr. James, I'm terribly sorry to take you back, but just before you leave that, 79 provides the answer certainly to the question they were asked.
Yes.
In other words, should we say of this judgment, as they did in Barber, yes, ordinarily judgments are retrospective, but this one isn't. What they don't address, as far as I can see, but you tell me if I'm wrong, is the question of whether the legislation is retrospective.
They don't say it in terms, but if one looks at 74...
But they don't address the question at all, do they?
Well, my lord, with respect, when one looks at 74 and understands how they understood the question that was being asked of them...
I follow, all right.
...and reads 79 in the context of 74... And I've already made the point that in 74 they are asking, they think they're being asked, must entitlement to the survivor's benefit at issue in the main proceedings be restricted in time? To which the answer is no need to restrict the effects of this judgment in time. Now, I appreciate the difference, but they clearly thought that that's what they were being asked. To which the answer, with respect, is
anyway, that's your answer. Yes, I've got it.
That is the answer.
Yeah. Thank you very much.
We do say it would be frankly bizarre if they had been sitting there all along thinking, well, actually, this question just doesn't arise at all because a much more severe limitation applies by reference to the case law that Mr. Kavanagh relies on. I'll just show your ladyship, your lordships, what happened when the matter returned to the German court. It's at MS 2918. This was appended to our application to intervene, to appeal, rather. If one looks at 2918, that's the judgment of the Bavarian Administrative Court. And you'll recall that on the question, the key question they were dealing with, which is, well, is this actually discriminatory at all? Is this discrimination contrary to the Framework Directive? The answer was yes, but only if life partners are factually in a comparable position to heterosexual or opposite sex couples, opposite sex spouses. So that was a question which the National Court had to consider. So if one then looks at 2921, the main question for the court, penultimate paragraph on 2921, the answer is given in the paragraph beginning, as regards survivors' benefits, there exists in national law a normative comparability between a marriage and a registered civil partnership. And then they explain why. Survivors' benefits are intended as a replacement for financial support. Married couples and life partners have the same mutual obligations to support each other, so the two statuses are normatively comparable. And it follows, see at 2922, that the claim succeeded. And if one looks at the order, one can see, if one turns back to 2919, one can see what that meant. Near the bottom of the page, in the paragraph beginning, in a letter of 24th April, the defendant confirmed that if the qualifying criteria were met, a monthly pension of €532 would be payable. And that claim succeeded. So the result of this claim is that Mr. Maruco was entitled to a monthly pension of £532, euros.
Much the same at present.
Yeah, indeed.
And possibly at that time as well.
Yeah. So €532, which he would not have been entitled to had he not succeeded in his EU law claim. Now, again, if the Secretary of State's argument were correct, Mr. Maruco should have received nothing or next to nothing, because all of the service, or almost all of the service to which the pension related, predated the transposition deadline. Now, can I move now to Römer, which, as I've said, deals with the question of retrospectivity in two respects. Now, this is another judgment. Both Maruco and Römer are judgments of the Grand Chamber, another judgment of the Grand Chamber, and the facts can be taken again from the Advocate General's opinion. If we just look at the beginning of the Advocate General's opinion on MS 384, this case concerns, paragraph 1, the interpretation of the general principles of union law, both primary and secondary, relating to discrimination on grounds of sexual orientation in employment and occupation. So it's a case that the court, the Advocate General, regards, and as we'll see, the court regards, as raising general principles of EU law. See also paragraphs 2 and 3 of the decision of the court, making the same point.
Who is the Advocate General?
The Advocate General is Advocate General Jaskinson.
I note, I imagine you'll be coming to this at a later stage in the argument, but in the German court's judgment, they did set out that the claimant's ability to rely on the directive arose from the fact that he was relying on it as against a public authority.
Yes, and that's what I need to address when I come to Kuciak de Vici.
Yeah.
So that issue wasn't raised in that case, but it is raised in our case, but there's an answer to it, which is Kuciak de Vici. So if one then looks at Römer, the provisions governing Mr. Römer's entitlement to pension are set out at paragraphs 19 to 25 of the Advocate General's opinion, MS 388 to 9. Essentially, the monthly amount of Mr. Römer's pension is a proportion for each year of service of the notional pay that he would receive. But notional pay was calculated net of notional tax. And the notional tax category applied to married persons, see paragraph 25, resulted in a higher pension payment to them than to non-married persons.
Effectively because there was a married person's tax allowance.
Yes, exactly. Yes. Now, given what Mr. Coppell says in his case about this, at paragraph 57, it is necessary to be clear that this was a case about discrimination in pension provision, not a case about discriminatory taxation arrangements. That is clear from the fact that this was a claim brought under the Framework Directive, which, of course, governs pay. It doesn't govern taxation. One of the issues before the court was, is the supplementary pension in issue pay within the meaning of the Framework Directive? And the answer was yes. Now, you can see from paragraph 27 of the Advocate General's opinion that this is a case where Mr. Römer worked for the defendant in the main proceedings from 1950 to 1990 when he became unwell. He had lived with his partner since 1969, and the two had entered into a life partnership in 2001, which is when those became available in Germany. After that, he wrote to his employers asking them to recalculate his pension, see paragraph 27. So pausing there, this is another case, well, this is a case, in fact, where the entirety of the service to which the disputed pension payments related took place before, and indeed long before, the transposition deadline, or indeed the adoption of the Framework Directive, and long before the claimant entered into a civil partnership. That means that if the respondent's arguments are correct, Mr. Römer should have received nothing. Now, the employers refused to treat Mr. Römer in the same way that they would treat a married person because under German law, only married persons were entitled to the higher pension payments he sought, see paragraph 28. And Mr. Römer's complaint was under the Framework Directive, see paragraph 31. The questions referred are set out at paragraph 34. Again, the first question you see is, are the supplementary pension payments at issue within the scope of the directive? The second question, again similar to what had been referred in Maruco, is that the answer to that question affected by recital 22 of the directive? Now, these first two questions are answered by the Advocate General at 47 to 86 of his opinion, and by the court at 29 to 36. And the answer given by both is that the supplementary pension payments in dispute did constitute pay within the meaning of the Framework Directive. Now, we don't need to concentrate in great detail on the reasons why that is so, because it's accepted that in this case, that the pension we're dealing with here does constitute pay within the meaning of the Framework Directive. Now, the third question was whether the differential treatment gave rise to discrimination contrary to the Framework Directive, and the Advocate General's answer is at 83 to 100 of his opinion, MS 396 to 399. And he concludes at paragraph 100 that in the light of the facts stated by the National Court, the situation of Mr. Römer is comparable to that of a married person so as to give rise to direct discrimination. My lady, my lords will recall that in Maruco's case, the Advocate General thought it wasn't direct discrimination, it was indirect. The court corrected him on that, and the Advocate General has reached the right answer here. It's direct discrimination. So then the Court of Justice addresses question 3 together with question 7, which the referring court had added after it had made its initial reference. And that, in the Court of Justice's judgment is between 37 and 52 on MS 416-7. And the answer, in short, is that there was direct discrimination if the legal and factual situations were comparable, and that was a question for the National Court. So very similar analysis to the one that we've seen in Maruco. And then note what is said on page 417, paragraph 52. The answer to questions 3 and 7 is that the directive does preclude a provision of national law, such as the one in issue, under which a pensioner who's entered into a registered life partnership receives a supplementary retirement pension lower than that granted to a married, not permanently separated pensioner, if, in the member state concerned, marriage is reserved to persons of different gender and exists alongside registered life partnership, and there is direct discrimination because the factual and legal situations are comparable. So that's the answer that it gives. Now, the fourth question was whether, if the discrimination did not contravene the directive, it nonetheless contravened Article 141 or a general principle of community law. Now, the Advocate General considered, of course, that the pension rules did contravene the directive, so the question didn't arise formally. Nevertheless, he went on to answer it for completeness. See his paragraph 116 on MS 401. And his analysis of the part of the question concerning the general principle of EU law is at 122 to 134 on MS 401 to 3. And I just ask you to look at one part of that. It's at 129. In my view, from a strictly legal perspective, there is no justification for applying the principle of equal treatment less rigorously with regard to discrimination on grounds of sexual orientation than with regard to discrimination based on the other grounds mentioned in Article 13 EC. To accept that there are in this area special sensibilities with legal effect would mean that the court accords significance to unjustified prejudices, whatever their origin, and denies equal legal protection to persons of a minority sexual orientation. So that's his answer. And then if one goes forward to 131, in the light of these considerations, I consider that in the same way as the court decided with regard to discrimination on grounds of age, the prohibition on discrimination on grounds of sexual orientation should be regarded as a general principle of union law. So there is the Advocate General recognising the principle of non-discrimination on grounds of sexual orientation as a general principle of union law. Now the court, if one goes forward to 419, agreed with the Advocate General that it was not necessary to answer the fourth question, and so just doesn't answer it. Nevertheless, its answer to question 5 takes it as read that the general principle of non-discrimination under EU law does extend to sexual orientation. See paragraphs 59 to 60 on page 418. You'll see that in 59 there is reference to the general principle, and in 60, for the principle of non-discrimination on the ground of sexual orientation to apply in a case such as that at issue in the main proceedings, that case must fall within the scope of EU law, see Kuchuk de Vici. So there is an assumption, although not perhaps a direct statement, that the principle is indeed a principle of EU law. And as we will see when we come to look at this point later, that has been specifically affirmed in subsequent case law of the court. So it isn't really in dispute. I don't know whether it's in dispute, but it shouldn't be in dispute that the principle of non-discrimination on grounds of sexual orientation is now a principle of general principle of EU law. Now, the fifth question was whether Mr. Römer could rely on the directive, A, before German law was amended to give effect to it, and B, even before the expiry of the transposition deadline for the directive. It's important to understand in our submission that the question had these two parts. And the two parts of question 5 are carefully explained by the Advocate General. A is dealt with at paragraphs 137 to 139, and B at 140 to 143.
Could you just say that again, please?
I'm sorry, yes. A is explained at 137 to 139, and B at 140 to 143. Now, as to B, the question was, from when does the right to equal treatment, can it be relied, from when can the right to equal treatment be relied upon? And the choices before the Advocate General and the Court were 2001, when German law first recognised life partnerships, and that's the date favoured by the Advocate General, see paragraphs 152 to 153. Or 2003, which is the transposition deadline for the directive, or 2005, which is when an amendment to the German life partnership law came into effect, further approximating a life partnership to a marriage. So the background is that German law made life partnership similar to marriage in some respects in 2001, and then it was further approximated to marriage later on. And that's a possible date that was suggested by the National Court, see paragraph 141. Now, the Court of Justice deals with the two parts of question 5 at paragraphs 53 to 56, and that's at MS 417 to 8. That's part A, 53 to 56, and part B, 57 to 64, on pages 418 to 9. Now, the answer to part A was that the directive could be relied upon against the state, even when it was acting qua employer. See 55 to 56. So if one just looks at 55 to 56, where the necessary conditions for the provisions of a directive to be relied on by individuals before the national courts against the state are satisfied, they may do so regardless of the capacity in which the state is acting, whether as employer or as public authority. Accordingly, if a provision such as the one at issue constituted discrimination, the right to equal treatment could be claimed by an individual against a local authority, and it would not be necessary to wait for that provision to be made consistent with EU law by the national legislature, taking account of the primacy of that law. So that's the answer to question A, part A of question 5. Now, the court's answer to part B was that the right to equal treatment could only be relied on at the earliest from the deadline for transposition of the directive, namely December 2003, because it was only at that point that the case came within the scope, the material scope, of EU law. See paragraph 64. Now, it's absolutely vital to understand what the court meant by that. What they meant was that Mr. Römer could not claim backdated supplementary pension payments at a higher rate in respect of a period prior to 3rd December 2003. So he couldn't go back to pension payments that were due prior to that date and claim those. It did not mean that he couldn't claim pension referable to service before that date, because all his service was prior to that date, long prior to that date. So it would have made no sense at all to be puzzling over the question, well, is it 2001 or 2003 or 2005 that's the relevant date? If, as the Secretary of State says, no pension was due in any event, because the service all predated 2003.
Service finished in 1990, did it?
Yes.
Yep.
Now, the sixth question actually makes this point even clearer, because the sixth question was about temporal limitation, and it was about whether, in accordance with the grounds of the Court of Justice's judgment in Barber, the principle of equal treatment was to be applied, quote, only in respect of that portion of pension entitlement earned by the pensioner from 17th May 1990. Now, the applicant and the Commission agreed that there was no reason to limit in time the effects of the judgment which was to be given. See the Advocate General at 155 MS 405. The Advocate General agreed with that, see 156 to 162, and especially see 159 and 161. Just ask your Ladyship and your Lordships to look at 161. The National Court observes that far from referring to the fear of serious problems, the Freie und Hansestadt Hamburg, on the contrary, pointed out that only a few cases of pensioners living in a civil partnership would have to be the subject of decisions applying the new method of calculating pension entitlement. The applicant in the main proceedings states that there are fewer than 15,000 registered civil partnerships, and that the number of retired employees of the local authority having a partner of the same sex is not such as to give rise to serious financial consequences. If the court were to reply in the affirmative to the questions above, the economic repercussions of that decision would therefore be minimal. And I just ask, my learned friend points out quite rightly that I should just ask you to note paragraph 160 immediately above. The financing of the retirement scheme concerned must have been planned taking into account the possibility of changes in the marital status of pensioners. There is no indication that that possibility increased significantly owing to the introduction of life partnership into German law. Well, that is exactly the same position that we are faced with here. No evidence at all that there are any material difficulties caused by the extension of this benefit to civil partners and same-sex spouses.
I suppose one could theorise that there might be such evidence.
Yeah. There might be.
On the basis that actuaries, being careful people, will predict that a certain proportion of members of a pension scheme will get married and will predecease their spouses and will therefore need survivors' benefits, and that a proportion of those who don't get married would enter into civil partnerships, thus increasing those two risks slightly.
Well, one could hypothesise that is a possibility, but it is no more than a possibility because, as I think my lady has pointed out I think it's in Bull and Hall, actually, in Preddy and
But we now
Lady
call it Bull
Moseley.
and Hall.
Bull and Hall.
Yes.
Of course, this is not a case where there is a category of individuals who could never get married before, but can now get married. Because, as everybody knows, lots of gay people got married through the ages to people of the opposite sex. What happened in 2004 and 5 is that they were permitted for the first time to get married to the people they actually wanted to get married to. So that's what happened in 2004, 2005. And that's why, if an argument were going to be made that this change seriously unsettled the financial basis of these schemes, it would need to be made on the basis of evidence. And there is no such evidence. Indeed, as Lord Justice Underhill pointed out, paragraph, I think, 61 of his judgment, that there simply is nothing to suggest that the extension of this rule will unsettle either this scheme or schemes in general. So the Court of Justice's answer to this point is at paragraph 66. And you'll see that on page 419. And it is that the Barber limitation has no bearing on the case, notwithstanding the fact that the contributions underpinning the entitlement had been paid before the date of the judgment. So just concentrating on that section, on that sentence again, notwithstanding the fact that the contributions underpinning the entitlement had been paid before the date of the judgment. We do ask the question, with respect to my learned friends, why did the court use that language if, as the Secretary of State says, there can be no sexual orientation discrimination claim in respect of pension referable to service prior to 2003? It would be bizarre to have used that language in those circumstances. And the question is even more pertinent with respect in a case where the whole of the service on the facts of the case predated 2003.
Can I ask you, I was a little bit puzzled by this yesterday. And, I mean, one sees in the second sentence
Yes.
that it's pointed out that nobody's suggesting there should be any limitation, and there's no evidence to suggest that a limitation is necessary. So on that basis, one could obviously distinguish Barber.
Yeah.
But they're not doing that. And that's put forward as furthermore. It's an additional reason. So on the face of things, they're saying in the first sentence that the nature of the dispute is such that Barber can't have any bearing. And I wasn't sure why that was the case.
Well, Lord, it may be that they are in fact alive to the fact that some of the considerations in Barber are akin to, as Mr. Kavanagh says, they're not exactly the same as, but they're akin to some of the considerations that one sees in some of the legislation cases. And so what the court is saying is, first question, do those considerations, let's call them the legitimate expectations considerations, do those considerations mean that you can't have a claim in respect of pension referable to service prior to 2003? Answer, no. You do have a claim, notwithstanding that the contributions are made prior to the transposition deadline. Furthermore, another point, if we're then going to actually ask the Barber question stricto sensu, which is, should we limit the effect in time of the judgment, then on that question, we simply haven't got any evidence to suggest that the pension scheme will be that there's any problem. So the answer is no. And so one can potentially read it in that way. And I would, with respect, accept that that is a possible reading of paragraph 66.
When I read it, I thought it was some sort of timing point being made, because the emphasis in the second line is on the fact that pensions paid from 2001, and then they refer to the fact that Barber is drawing a line in 1990. But I didn't understand what the timing point was. If that was...
my Lord, what that point does, if I may respectfully say so, is it points to a tension in the Secretary of State's argument, because on the one hand, Mr. Kavanagh is at great pains to say that the considerations and the language underlying the Barber line of case law is reflected in the other cases that deal with legislation. It's all the same, basically. They're talking about whether situations are permanently fixed and whether their effects are exhausted and all the rest of it. But on the other hand, he says, when the court is actually looking at the very question they're being asked, well, should there be a limitation by reference to periods of service prior to a particular date, 1990? Oh, you just ignore that because they were being asked something completely different.
Well, never mind what they were being asked. I think what may be said, and I think I've got your answer, is they simply haven't addressed the difference between when the pension is payable and the service by which to which it is referable.
Yes, well, they've addressed precisely that issue, with respect, my lord, because what they're looking at when they're answering question 5b, is can you claim backdated pension which was due prior to 2003? Answer no.
Oh yes, they've done it there.
And they've clearly done that. And they cannot have been talking about pension referable to service prior to that date, because all of it was referable to service prior to that date. So they have clearly distinguished between these two elements or aspects of retrospectivity. One of them offends the rule, the other one doesn't. And that's what they're saying, we would respectfully submit. Now, I'll just give you the reference rather than going to it, given the time. But you have at MS 2923 a copy of the consent order made by the German court in this case, which indicates at least how the parties understood the effect of the judgment. Of course, we accept it's only a consent order, but it does indicate that at least the parties understood the court's judgment as indicating that some compensation was due, notwithstanding that the whole of the pension was referable to periods of service prior to the transposition deadline. Now, we've set out, and I'm not going to go through it in great detail at this stage, but we have set out in our case at paragraphs 52 to 70, MS 2973 to 292, where we say the EAT and the Court of Appeal went wrong in analysing these two decisions, Maruco and Roma. Can I just invite your ladyship and your lordships to look at what the Court of Appeal said about this at paragraph 35 of its decision at MS 3063. Now, at 35, Lord Justice Lewison starts by saying that the pension trustees can't be expected to confer on Mr. Walker a benefit to which he is not entitled. Well, if, Lady Lords, by that was meant Mr. Walker doesn't have a contractual entitlement to have this benefit paid to his husband, that is, with respect to Lord Justice Lewison, obvious. We wouldn't have to bring a discrimination claim if he had a contractual entitlement to the benefit. Next, Lord Justice Lewison says that conduct that was lawful when it occurred cannot retroactively become unlawful. We agree, but we're not complaining about anything that was done by Innospec during Mr. Walker's period of service. As I've said at that time, Mr. Walker was not married and not in a relationship equivalent to a marriage. The complaint is about the respondent's failure to allow him access to the spouse's pension that he has earned on non-discriminatory terms once his partner acquired a status that was legally and factually equivalent to that of a spouse. That became unlawful from December 2003, as both Maruco and Roma show. Next, Lord Justice Lewison says that Mr. Walker's entitlement to pension was definitively established or permanently fixed as he earned it, and a fortiori cannot have been enlarged following his definitive retirement. Well, there are two answers to this. First, to say that his entitlement was definitively fixed as he earned it presupposes the very question on which this case turns. Second, and in any event, Mr. Walker is not trying to enlarge his entitlement. He is merely seeking access on non-discriminatory terms to the spouse's pension that everyone agrees his wife could have if only he had married or were to marry a woman. Now, the key parts of Lord Justice Lewison's summary of Maruco can be found at 37 to 40 in the judgment. He said that question 5 in Maruco was a very puzzling question because Barber was about temporal limitations on the effect of judgments, not temporal effects, not the temporal effect of changes in legislation. Thus, even though the respondents in Morocco had advanced precisely the argument being advanced here, as noted by the court at paragraph 75, and even though the court rejected it in general terms at 79, they gave what he said was an unnecessary answer to the wrong question. Well, as we've said, that involves assuming that the court decided to answer a question that simply did not arise because either the whole or nearly the whole of Mr. Morocco's pension fell outside the scope of the EU principle of equal treatment for quite separate reasons that are not mentioned anywhere in the judgment. And we, as we've said, that is a bizarre reading of the judgment as a whole and not one that the German court shared. As to Römer, Lord Justice Lewison summarises at 41, question 5, but his summary only includes part B of that question, which is whether Mr. Römer was entitled to be treated as a married person even before the transposition deadline. At 44, he says the answer to that question was negative, so question 6 didn't arise. But the difficulty with that is that there were two parts to the question, and he omitted part A. Part A had asked, if you recall, whether the Framework Directive could be relied upon against the respondent before national law had been brought into line with it. That part had been answered in the affirmative, so question 6 did arise. Moreover, the general statements in paragraphs 52 and 56 contain no condition that the service must post-date the transposition date for the Framework Directive, and that might be thought a very surprising omission in a case where the whole of the service predated by many years the transposition deadline. So that concludes our submissions on Morocco and Römer. Can I move now to Paris? As we've said, the Paris case concerned a pension scheme that was materially different from Mr. Walker's in one crucial respect. To be entitled to a spouse's pension, the marriage or civil partnership in Paris's case, and just pausing there for a moment, that the pension scheme involved in Paris's case actually applied both to marriages and civil partnerships on its face. But to be entitled to a spouse's pension, the marriage or civil partnership had to have been recognised before the member reached the age of 60 or before retirement, whichever was the earlier. See paragraph 17 of the court's judgment at Authorities Bundle 1, tab 8, MS 298. At that time, Irish law didn't recognise civil partnership, see paragraph 18. And the questions, which you can see at paragraph 29, ask simply whether the effect of this rule gave rise to either sexual orientation discrimination or age discrimination, or combined sexual orientation and age discrimination. Those were the questions asked. Note that those questions do not include any question about the significance or otherwise of the fact that all of Dr. Paris's service predated the recognition in Ireland of civil partnerships, and most of it predated the transposition deadline for the directive. Nonetheless, as I've said before, the UK made observations designed to make precisely that point. Now, I'm going to show you the Advocate General in a moment, but can we start with the court at 31 to 42, MS 299 to 300. There, you have a discussion by the court about whether the rule falls within the material scope of EU law, and the answer at 42 is yes. Note that there is no discussion here of the separate argument advanced by the UK that the rule does not fall within the temporal scope of EU law because the contributions were made before Ireland recognised civil partnerships and largely before the transposition deadline for the directive. So the court then confines itself to the questions asked and concludes that the rule, which, as I've said, applies on its face both to married people and civil partners, was neither directly nor indirectly discriminatory on grounds of sexual orientation or age. The conclusion on direct sexual orientation is at 49 to 50. Indirect discrimination is considered at 51 to 61. And then at 54, the court notes that Mr. Paris did not satisfy the conditions to be eligible for a survivor's pension because he entered into a civil partnership after his 60th birthday. At 59 to 60, it was said that member states are free to decide whether to allow civil partnership or same-sex marriage, and if so, whether to make it retrospective. Now, just on this point, can I just address that question, the question, what was meant by saying states can decide whether to make civil partnership or same-sex marriage retrospective? What it meant was that member states are free to decide, one, whether to recognise a status equivalent to marriage, and two, if so, whether to stipulate that persons should be recognised as having held that status from a date prior to the date on which they were actually recognised. So it would be open to a state to come along and say, your civil partnership is hereby recognised, and I'm going to deem you as having been married from a previous date because that's when you started living together or something.
Oh, it might be when you contracted a civil partnership in another jurisdiction.
Exactly.
Which is
Could be.
the Irish situation.
Exactly. Could be that. But it's up to them. They can decide whether to make it retrospective in that sense or not. Now, if Ireland had made civil partnership retrospective in that sense, that might have saved Dr. Paris, because it would have enabled him to say that he should be treated as having been in a status equivalent to marriage at the time of his 60th birthday. But Mr. Walker's scheme does not require that he be married at the time of his 60th birthday, or indeed at the time of retirement, or at any other time prior to his death. The only stipulation is that he be married on his death. So the failure of Dr. Paris's discrimination complaint does not matter at all for our facts. Now, it's already been accepted by Mr. Kavanagh correctly in my respectful submission that nothing was said by the court about the argument that had been advanced by the UK based on the fact that Dr. Paris's service related to a period prior to the recognition of his civil partnership. They simply didn't deal with the point. The Advocate General, on the other hand, did deal with the point. And although Mr. Kavanagh tried to say, well, it was just a small part of the Advocate General's judgment, it was the part of her opinion which dealt with the point that had been specifically advanced to the court by the United Kingdom. And you've already seen it, so I'm not going to read it out again, but can I just take you to one part of it? Paragraph 41 on page MS 316. Consequently, she says, the court has already declared the Framework Directive to be applicable to cases concerning occupational and survivors' pension schemes, the entitlements under which had arisen, much as they did here, long before the entry into force of that directive, and any contributions or reference periods in respect of which also predated the entry into force of that directive. Now, when she then refers in footnote 19 to various passages in the Advocate General's opinion and judgment in Maruco and Roma, what she is doing is she is simply taking the reader to those parts of the judgment, essentially those parts of the opinion and judgment, which I've taken you to this morning. She is simply saying, when one looks at those two cases, you can't read them any other way than as saying that the directive is applicable to cases notwithstanding that the entitlements had arisen before the entry into force of the directive. And if one then goes on, the court expressly did not apply a temporal limitation restriction to the effects of its case law relating to occupational pension schemes. I would add that there was, moreover, no longer any need for such a temporal limitation, since it had become sufficiently apparent since the judgment in Barber that occupational pension schemes fall within the EU concept of pay. And then at 42, it's true that the court has held that the prohibition on discrimination contained in the directive cannot give rise to claims for payments in respect of periods in the past that predate the time limit for transposing the directive. That again is talking about backdated pension payments that are due before the coming into force of the directive. However, the recognition of the right to a future survivor's pension at issue in the present case is unaffected by that principle, because such recognition is concerned only with future pension scheme payments, even though the calculation of those payments is based on periods of service completed or contributions made in the past. We say that Advocate General Cocotte was 100% correct there. She got it right as to what those two cases said, and we would respectfully submit that this court can and should follow her interpretation of Maruco and Roma. Now, can I move on to the question which my Lord Reid put to me a moment ago, which is, does it matter that we are here dealing with a claim against a private pension scheme, Innospec, rather than a public sector defendant? And that, the answer to that question depends on the judgment of the Grand Chamber of the CJEU in Kuchuk Devici, which you have in Authorities Bundle 6, tab 80, MS 1846. Now, Kuchuk Devici was a case in which an employee brought proceedings against a private employer. The employer relied on a provision of national legislation which permitted age discrimination that she said was contrary to both a general principle of EU law and the Framework Directive. The questions are set out by the court at paragraph 17, MS 1869. 1A asked whether the national provision infringed either primary community law or the directive. 2 asked whether, if the provision in issue was contrary to EU law, a court of a member state must disapply the offending statutory provision in proceedings between private individuals. And it's 2 that we are primarily concerned with. Now, the answer to question 1A starts at paragraph 19 at 1870. At 20, the court notes that it's already said in the Mangold case that the principle of equal treatment in the field of employment and occupation did not spring from the directive. The directive was adopted on the basis of Article 13 EC, now Article 19 TFEU, and that merely provides a general framework for implementing the principle. At 21, the court notes, again on the basis of the Mangold decision, that non-discrimination on grounds of age is a general principle of EU law. At 22, reference is made to Article 21(1) of the Charter, and at 23, the point is made that for the principle of non-discrimination to apply, the case has to fall within the scope of EU law. At 24, the CJEU noted that the allegedly discriminatory conduct took place after the deadline for transposing the directive, and at 25, it noted that from that date, conditions of dismissal came within the scope of EU law. And at 27, you can see that it is a general principle of EU law, as given expression in the directive, that is the prism through which one has to analyse the compatibility of national legislation with EU law. Now, if we then go to the court's answer to question 2, which one finds at paragraph 44 and following, 45 to 48, the court notes that the duty of the national court is first to interpret domestic law insofar consistently with EU law insofar as possible. 49, the German provision in issue is not capable of a conforming interpretation. 50, the directive merely gives expression rather than laying down the principle of equal treatment in employment and occupation, and the principle of non-discrimination on grounds of age is a general principle of EU law, in that it constitutes a specific application of the general principle of equal treatment. And 51, the court then holds in those circumstances, it is for the national court to provide, within the limits of its jurisdiction, the legal protection which individuals derive from EU law, and to ensure the full effectiveness of that law, disapplying, if need be, any provision of national legislation contrary to that principle. So that's the answer, we say, to my Lord's question.
So you say, that was obviously dealing with the principle, as you say in paragraph 51, the principle of non-discrimination on grounds of age.
Yes.
And you would say that by analogy, sexual orientation is in the same position.
Yes, and I'm going to show you authority for that just now. We do say that, and that is now firmly established. So there are three pieces of authority that we rely on for the proposition that the principle of non-discrimination on grounds of sexual orientation is also firmly established a general principle of EU law. One is what we've already shown you, which is Roma paragraphs 59 to 60, which assumes, without actually stating, that it is. The second is a case called Léger, which is a recent decision of the court, and see in particular paragraph 48 of the court's judgment in that case, MS 1923. Accordingly, among the provisions of the Charter, that decree, that's the decree at issue in that case, must respect inter alia Article 21(1) thereof, according to which any discrimination based on sexual orientation must be prohibited. Article 21(1) is a particular expression of the principle of equal treatment, which is a general principle of EU law enshrined in Article 20 of the Charter. So that is an express endorsement of the proposition that it's a general principle of EU law. And finally, exactly the same is said by Advocate General Cocotte in Paris at paragraph 3 of her opinion, MS 309. So we say what that shows is that Innospec's refusal to provide a pension to Mr. Walker's husband would contravene the general principle of non-discrimination on grounds of sexual orientation. And if EU law does not permit a temporal limitation such as is provided for by paragraph 18 of Schedule 9, then this court is bound to disapply the limitation. I'll give your ladyship, your lordships, just for your note, the reference to Chester, decision of this court, which confirms that the Kuciak-Devici principle does have the effect we say it has. It's Authorities Bundle 3, tab 39, MS 871, paragraphs 60 to 61. Now, can I deal quickly with what Lord Justice Lewison said about this in the Court of Appeal? At paragraph 49, MS 3068. He notes first that the answer to question 5 in Römer established that the right of equal treatment on the grounds of sexual orientation did not become part of EU law until 2003. He then says that Mr. Walker retired and his entitlement to pension was definitively established before that date. it followed that there was no need to disapply paragraph 18. Well, there are two answers to that. The first is a general one. It doesn't matter when the principle of non-discrimination on grounds of sexual orientation became a general principle of EU law. What matters is that it is one now, and that is beyond doubt. Secondly, just as a matter of accuracy, the court in Roma did not actually say that the principle of non-discrimination on grounds of sexual orientation had only become a principle of EU law in 2003. What happened in 2003 was that from the transposition deadline for the directive, conditions of pay fell within the material scope of EU law. Can I just respond briefly now to what Mr. Koppel says about the Kucic-De Vici case at paragraph 68 to 70 of his case, MS 3034. His first point in paragraph 69 is that there is no general principle that same-sex couples, even in a legal relationship, should be entitled to the same benefits as married couples. We don't rely on any such general principle. The principle we rely on is a much simpler principle. It's the principle of non-discrimination on grounds of sexual orientation. Once you have concluded that Innospec would breach that principle if it failed to pay a pension to Mr. Walker's husband, there can be no doubt that the court is required to disapply paragraph 18. His second point is that Kucic-De Vici was referred to in Roma, but it was still not possible to claim backdated pension benefits payable prior to 2003. Well, that's right, but that's because those pension benefits did not fall within the material scope of EU law until 2003. But as I've said already, we're not trying to claim any benefits that were payable or due prior to 2003. In any event, this point arises if and only if we have already succeeded in showing you that Maruco and Roma, in the light of those two cases, EU law does not defeat all claims to pension benefit simply because the service to which the pension relates predated 2003. This Kucic-De Vici point only arises if I have succeeded in showing that Maruco and Roma, as the Advocate General said in Paris, show that there is no bar to an EU discrimination claim, notwithstanding that the service to which the pension relates predated 2003. This point is solely directed to the question that my Lord Reid put to me in argument, which is, does it matter that this is a private scheme? Answer, no. My fifth head is reference to the CJEU, and it was put to me, I think, that perhaps I'm trying to have my cake and eat it by saying, well, this case is clear in our favour, but certainly can't be clear against us. We say, actually, when one looks at it, Maruco, Roma, and the Advocate General's application of those cases in Paris, rejecting precisely the argument being run by the Secretary of State in this case, show that the point is clear in our favour. If you agree, there is no need, at least in this case, for any reference to the CJEU. If you do not agree with us that the point is clear in our favour, then the most that can be said by the Secretary of State is that the point is unclear and has to be referred. Can I deal
wonder whether that's right. I mean, the problem in this case is not lack of guidance from the European Court, but it's trying to work out what it means. And I wonder whether that sort of case isn't ready for us to grapple with it and make a decision. I mean, sending it back yet again to Europe doesn't mean we're going to get any more clarity. They'll just presumably repeat what's been said. We don't have to. I mean, really, it's the application to the facts of principles which, like it or not, should be apparent from the cases we've been looking at.
My Lord, I don't dissent from that at all. Our primary cases, you look at Maruco and Roma, You look at what Advocate General Cocotte said in Paris, and we win this case. And that's where it should end. What you can't do, with respect to my learned friends, is say that the case is act clair against us in the light of what Advocate General Cocotte has said in Paris. You would be saying, and Mr. Kavanagh has actually already put it in these terms, she got it wrong. And that is not a very propitious basis.
What Mr. Coppell says, not only did she get it wrong, the court made it clear that she got it wrong.
Yes.
And if he's right about that, then he wins.
Of course.
So it's just that, I mean, the sort of Silphit principles which were laid down years and years ago rather assumed you hadn't got a whole body of European law. We've got an enormous body of European law. It's just a matter of trying to work out what it means.
I accept that, but my submission, as I've explained, is you can decide it. It's clear in our favour.
Yeah.
See Maruco Roma, Advocate General in Paris. What cannot be said is that it's clear against us because there is simply nothing in the court's decision in Paris that shows that the point we're dealing with here, the Advocate General got it wrong.
Could it be clear in your favour, but not clear in Mr. O'Brien and the Miller appellant's case?
Well, Lady, I have thought about that question, and I think the answer is that we've got two cases here, Maruco and Roma, which are about sexual orientation discrimination in relation to pension provision. They are bang on point. And one of them, Maruco, is about a claim for survivor's benefit. Sexual orientation, survivor's benefit, it is bang on point. And so we do say, I obviously heard what Mr. Allen said about the need for a reference in his case, but we do say that at least so far as the position concerns the facts of this case, they are determined in our favour by Maruco, Roma and Paris. Lady, can I deal in such time as I have available with the ECHR aspect to the claim? You have it set out in our case, and we've set out at paragraph 89 of our case the list of questions that has to be answered in an Article 14 case. They will be very familiar to the court, so I won't labour them. Mr. Coppell, on the other hand, makes 2 points at paragraphs 72 to 73 of his case, MS 3035. His first point is that the Convention, like EU law, doesn't compel contracting states to allow same-sex couples to marry or to allow them to enter a relationship that is similar to marriage in all respects. We agree. That is why in the German cases, the German courts had to consider, under the rubric of EU law, of course, whether the life partnership that was offered under German law was really similar in respect of the particular benefit under consideration. And the answer was yes. The answer is the same here too. Civil partnership, when it was introduced, and same-sex marriage are similar to opposite-sex marriage in the relevant respects. Section 23 of the Equality Act says so in terms. Of course, one can always say that the very provision under challenge makes them different in at least one respect, and that is one of the things that's said against us. They say, well, paragraph 18 itself shows that in this particular respect, same-sex marriage and or civil partnership is different from opposite-sex marriage. But of course, the same was true in the two German cases, and it will always be true in any case where it's necessary to invoke EU or ECHR rights. If national law provided equality in every respect, there would be no need to invoke either EU law or the ECHR. Now, before the EAT, Innospec made a very similar argument in denying that when one applies the test in Roma, civil and married couples are in comparable positions for the purposes of survivors' benefits. The EAT rejected that argument, quite correctly we would say, at paragraph 41 of its decision, MS 3097, by reference to a submission made on behalf of Mr. Walker, and referred to it as a bootstraps argument. That is actually what it is. You cannot simply say, as they seek to do, well, with one bound, we're free, because the very provision whose compatibility we are debating itself shows that national law treats same-sex couples differently from opposite-sex couples. Mr. Coppell's second point is by reference to a case called Thomas, which you have in the bundle, Authorities Bundle 4, tab 54, MS 1264. The short point about Thomas, and the short point about Thomas is that, as in Paris, the applicant was not in an analogous position to a married man. All of the court's statements of principle in that case proceed from that starting point. That case is not authority for the proposition that different treatment of people in comparable situations is permitted by the ECHR in respect of pension benefits based on service before the right to non-discrimination applied. Now, there is in the supplementary bundle, and I mention it now, I can come back to it in reply if I need to, a case called Andreeva, which is an example, although the point wasn't taken in that case, supplementary bundle tab 6, it's an example of a case where pension was referable to service prior to the contracting state in question, Latvia, acceding to the ECHR, and despite that, the claim succeeded. Now, can I just finally deal in the couple of minutes that I have left with the question of justification? Because we say, when you're dealing with the ECHR part of the claim, really what this hinges on is the question of justification. Now, on that, what is said against us is that the test is whether it's manifestly without reasonable foundation, whether the decision, the measure in question, is manifestly without reasonable foundation. Now, what we say about that is that this court's decision in Brewster, which I know some members of this court were party to, Lord Kerr and Lord and Lady Hale and possibly others too, I forget. Yes. It shows that the level of scrutiny must intensify if the justification now put forward was not squarely before the decision maker when the relevant decision was taken. That's what we take from Brewster. Now, what we have here is a provision that was originally introduced by way of secondary legislation at the time when the Civil Partnerships Act was introduced, and it was simply maintained in the same form when the 2010 Act came in. Now, before the EAT, the estimate of how much it would cost to make survivors' pensions available to same-sex couples came in at 88 million, which was about 0.007% of private sector defined benefit schemes' total accrued liabilities. See MS 3233, paragraph 2.2. But there was a possibility, just ask, if you'd indulge me for at least 2 minutes beyond my allotted time, just ask your ladyship and your lordships to look at 3233 in the bundle. This is a GAD document, Government Actuaries Department document. And so, as one can see from 2.2, the estimate was 88 million. But at 2.5, you can see it could be as much as 35 times that amount, which would be 3 billion. And here's what GAD says about that. That 3 billion would still represent less than 0.25% of schemes' total accrued liabilities. Therefore, the overall conclusion would remain that the additional costs of providing survivors' pensions to civil partners and same-sex spouses for service accrued before 2005 would be expected to be small relative to the value of schemes' total accrued liabilities, although the monetary amount could be of the order of 3 billion. Now, that was what was being predicted when this case was before the EAT. Since then, there has been a further estimate given, and the final figure now given is 100 million. So 1/30th of the figure that GAD said was small. 1/30th of it. Just to give you an order of magnitude.
Sorry, where does that 100 million figure come from?
It comes from a document which is appended to the Secretary of State's case. I'll give you, in due course, the reference to it. I don't have it right now. But just to give you an order of magnitude as to what we're actually dealing with here, the order of magnitude that we were looking at that was being considered in the Barber case, which caused the court to impose a temporal limitation on the effect of its judgment in that case, was between 33 and 45 billion in 1990. Roughly speaking, that you need to double those figures to get to what we'd be dealing with in today's money. Now that, in our respectful submission, justifies Lord Justice Underhill's observation at paragraph 61 of his judgment, MS 3070, that there is no evidence that the extension of the class of beneficiaries to include same-sex surviving spouses would seriously unsettle the financial basis of the Innospec scheme or of pension schemes generally. And that means, we say, that there is nothing to justify the serious discrimination to which paragraph 18 gives rise, and this court should therefore grant a declaration that the rule is incompatible with Article 14. My Lady, my Lords, I see I've read with Article 1 of the first protocol. I see I've already exceeded
So that's, you're 3 minutes over.
Yeah.
So they'll come off your half hour
Yeah.
at the end. But,
Yeah.
you only need this argument if you don't succeed on the EU law.
Well, my lady...
You do better on the EU law, don't you?
Well, my lady, I would accept that, but for one point. We do not know what is to become of EU law rights in the Great Repeal Bill that we are all promised. We hope, on the basis of statements that have been made, that we can take it as read that if indeed we have an EU law right, as we say we do, that right will come into domestic law when the Great Repeal Bill is introduced. But we do not know the detail. And so we do respectfully invite the court to make the declaration in respect of under Section 4 of the Human Rights Act as well, simply because of the uncertainty that we are in.
Surely, if you're right on the EU point, then there's no incompatibility, because our law is compatible.
For the time being.
We can't
paragraph
make a
18.
hypothetical
You
declaration.
want paragraph 18 declared incompatible. That's one argument, and the other argument is you want us to disapply it.
Yes,
And you like both because you don't know what's going to happen in 2 years' time.
we don't. Lady, unless I can assist further, those are my submissions.
No, thank you very much indeed, Mr. Chamberlain. Mr. Schaefer? Mr. Coffin.
My Lady, I am going to make submissions in 4 parts. Firstly, on the general principle that we say is determinative in this case, that conduct should not be penalised, which was lawful at the time that it occurred. Secondly, on the 3 stages, or what we say are the 3 stages by which EU law arrives at that result in this case. Thirdly, on the 3 cases which are at the heart of Mr. Chamberlain's submissions, the Maruco, Roma and Paris cases. And fourthly, on the ECHR claim. Mr. Randall is going to deal with the issue of disapplication of paragraph 18 pursuant to EU law and with certain other issues which are of particular interest to his clients.
And are your submissions directed only at the Walker appeal or also at Miller and O'Brien?
They're only directed at the Walker appeal. My Lord. Part 1, then. We invite the court to dismiss the appeal for the reason that Mr. Walker's complaint of discrimination is properly analysed as spanning a period prior to his retirement during which the less favourable treatment to which he was subjected was not unlawful. It is, we say, a principle common to liberal democratic legal systems that individuals should not, save in exceptional circumstances, be penalised or held liable for behaviour which was not unlawful at the time when it occurred. That would be the indisputable consequence if Mr. Walker's claim were to succeed. The Innospec pension scheme would become subject to a new and unforeseen liability to Mr. Walker and his same-sex partner, notwithstanding that its conduct towards Mr. Walker was perfectly lawful during the period when his pension rights accrued. And the same point can be repeated for other pension schemes up and down the country who will face similar claims. Now, let me explain that a little further. During his service with Innospec, Mr. Walker received pay. He received a salary and he accrued pension rights. He accrued a right to a standard retirement pension, a monthly payment after his retirement, based on a factor of his final salary and his years of service. Now, it was a conditional or contingent right. Yes, he could only have it if he reached retirement age, but it was a right nonetheless. And you have the scheme rules that show you what the right was, MS 3170 and 3167. Mr. Walker also accrued a right to a spouse's pension, which at the time of his employment was a pension for an opposite sex husband or wife who survived the member's death, and again to be based on his final salary and his years of service. Again, that was a conditional right, conditional on him being married, first of all, and then on dying before his spouse. But it was a right nonetheless. And you can see the right if you want to, MS 3173. Now that situation, which was very widespread amongst occupational pension schemes at the time, discriminated against homosexual employees. They accrued a right to a spouse's pension which was of no value to them because they weren't ever going to marry a person of the opposite sex.
Of course, it was of value if they did marry somebody of the opposite sex, which...
Yes, it was, but given the small likelihood of that happening, it was of less value to them than it was to a heterosexual person. So the pension rights of homosexual scheme members were, for that reason, less valuable than those of heterosexuals doing the same work. Now, I said that during his employment there was discrimination against homosexual scheme members. In fact, there was unequal treatment which was lawful at that time. It wasn't discrimination. It only became unlawful after Mr. Walker retired in March 2003 and had ceased to earn pension rights when the Directive and later the Civil Partnerships Act came into force. Now, if, sadly, Mr. Walker had died upon or shortly after his retirement in March 2003, and his partner had claimed the spouse's pension, then it is indisputable that no such pension could have been paid to his partner as a result. The rights that Mr. Walker had accrued during his employment did not extend to such a pension. Now, what is said to make the difference, then, is the coming into force of the directive in December 2003. That change of law is said to land the Innospec scheme with a new liability. an obligation to regard Mr. Walker as having accrued a right to a survivor's pension for his same-sex partner during his employment with Innospec, when that is not what happened in fact, and when the scheme had acted perfectly lawfully in treating Mr. Walker as it did during his employment. On that analysis, if that is right, if Mr. Walker's claim is correct, the directive would have rendered unlawful treatment which was lawful at the time that it occurred. That situation would be contrary to the principles to which I've referred. It would be seriously detrimental to occupational pension schemes like the Innospec scheme because of the way in which they operate, by collecting contributions from employers and employees which are calculated to be sufficient to cover their expected liabilities. Now, in the annex to our printed case, which begins at MS 3041, we've included some background material regarding the method of funding of defined benefit pension schemes, which we put in at EAT level when we became involved in the case, and if the court hasn't done so already, I would invite the court to read this in due course. I just want to make a few points from it. In paragraph 2, we describe broadly how defined benefit final salary scheme pension schemes work, the promise of pension based on years of service and final salary. At the end of the paragraph, we mention that once pension rights are accrued week by week, month by month, they are protected by law. They are protected by what are known as the subsisting rights provisions in section 67 and following of the Pensions Act 1995. And broadly what these do is they prevent potential detrimental changes to past accrued rights unless the member consents. Now, I'm going to hand up a small clip of supplementary authorities. It's 3 short extracts. One of them, the first one, is the subsisting rights provisions that I wanted to show you. So just take a moment for these to get to you.
This will be provided electronically.
Yes, it will.
Thank you. Yes, it will.
Now, these are complex provisions, and I'm not going to go through them in any detail. But can I show you the definition of a subsisting right, which you get to on the second page, the back of the second page of the print, so actually page 4. It's section 67A of the Pensions Act, subsection 6, the definition of subsisting right, which in relation to a member of an occupational pension scheme at any time is any right which at that time has accrued to or in respect of him in future benefits under the scheme rules, or any entitlement to present payment of the pension or the benefit which he has at that time. And it goes on. And the key to the subsisting rights provisions are section 67, that's the first page of the print, and the point is that 67.1, they apply to a power of trustees, etc., to modify a pension scheme. 67.2, any exercise of a power to make a regulated modification, which is a modification affecting subsisting rights, is voidable unless certain conditions are satisfied, generally unless the member gives consent, or in some cases either he gives consent or the actuary certifies that that the changes make no difference. How they work in fine terms doesn't really matter. The point is, once you earn your pension, you have a right, and you have a right week by week under the Pensions Act for that pension to be protected. It can't be taken away, save in very limited circumstances with your consent. So when we come back to talking about whether rights are definitively established, that's part of the picture. They are in fact protected by law once they are earned.
Is there a definition of accrued somewhere, or do we take that as read?
I'll come back to you on that.
All right.
So, going on through the annex on 3042, paragraph 4, we describe minimum funding requirements. Schemes have to keep a certain amount of funding on hand sufficient to cover their liabilities. That's paragraph 5 as well, the technical provisions as they're known. And then paragraph 6, and I think Lord Hughes referred to this yesterday, every so often trustees have to obtain actuarial valuations of their scheme in order to check whether they have enough money in the bank, as it were, to pay the liabilities which may fall due. And at each valuation, every 3 years or more frequently, the trustees and the actuaries who they instruct have to make assumptions. And that's paragraph 8 of the annex. They have to make assumptions about the scheme's expected future experience, assumptions about how the investments will perform, but also assumptions about how much benefit will have to be paid out, and that might be ordinary pension based on life expectancies, it may be spouses' pensions, health benefits, and so forth. They make assumptions. And paragraph 10, then, the short point is that these assumptions and the contribution plans which are fixed following the valuation, they are necessarily based upon the scheme rules and legislation as they appear at the relevant time. And it follows from that, we say just below letter D, that it would upset, and to a greater or lesser extent, of course, depending on the benefit concerned, depending on the scheme, but it would upset the financial balance of defined benefit pension schemes and the legitimate expectations of the parties to them if pension liabilities could be increased on the basis of law which was not in force at the time that contributions were made and pension benefits were accrued.
Do the actuarial assumptions include any element of the unpredictability of law reform and the impact that it may have on the pension scheme, or do they ignore that?
Well, the answer is it depends. It may do, depending on the actuary and depending on the issue. There may be a law reform which is on the horizon, which is reasonably clear it's coming down the road. They may plan for that, but as a matter of principle and subject to that sort of situation, they plan for the liabilities which the scheme is going to have based on the law as it stands, and they assume, because this is the way that pension law generally works, they assume that when the law does change, that it changes for service in the future, not for service in the past. And that's paragraph 11 of the annex. That's why changes to pension law generally take
Do we have a date for these
prospectively.
For this actuarial exercise? Is there a date on which the actuarial exercise was carried out?
Well, I'm not making specific submissions about the Innospec scheme. Mr. Randall has some facts of that. I'm talking about how this type of scheme works in general terms, and at least every 3 years there must be a evaluation. And then conversely, a retrospective increase, this is paragraph 12, a retrospective increase to accrued benefits, an increase which applies to benefits which have been earned by service before the relevant law comes into force, will increase the ultimate cost to schemes of providing those benefits require schemes to provide more expensive benefits than was expected when the relevant contributions were made. We go on, and Mr. Chamberlain's referred you to it already in paragraph 14 of this annex to summarise the evidence that we had obtained about costs to both private and public sector schemes of equalising survivors' benefits retrospectively, as Mr. Walker's claim would suggest. The final figures, or the latest figures, are on 3046 at the end of the annex, £100 million for private sector schemes, £20 million for public sector schemes, and that's MS 3262, if you want the reference to the document which says that. And I'll come back to what the significance of that is.
Mr. Coppell, when the trustees of these various schemes do the 3-year exercise, and there isn't enough, which from time to time there isn't,
Yes.
the shortfall has to be made up by whom?
Well, generally by the employer.
Quite.
Generally, but there will be circumstances where employee contributions have to increase as well for the future. Okay. And it's a matter for industrial relations, perhaps, as to
yes, but the default liability falls on the employer, does it generally? Yes, must do.
Yes. So, in the particular case of survivors' pensions, and this is a point which my lady made earlier on, where a scheme provides a right to a pension for a surviving opposite-sex spouse, as this Innospec scheme did, trustees' calculations from time to time of the necessary funding for the scheme will be based upon a prediction of how many scheme members are likely to die leaving an opposite-sex spouse. And the actuary will have figures and predictions for all these things.
A hugely complex exercise.
Well,
given the variations over the years in the propensity of people to marry, going down rapidly, and differences in life expectancy and so on. I wouldn't like to be an actuary. It's very, very difficult.
And they charge a lot of money for what they do. But that is what they do. Now,
do we know anything about whether, now that obviously discrimination is not going to be permitted for the future, schemes have upped their contributions to reflect the fact that their liabilities are going to be increased by what the government actually thinks is a pretty marginal amount?
Well, that's a marginal amount, in the grand scheme of things. That's to retrospectively increase for the past.
Yes.
For the future, people will be accruing benefits which will cost the scheme more because they apply to civil partners and same-sex spouses as well. And that may mean that the employer has to contribute more. It may mean that because the investments are done better than expected, it's not necessary. There are all kinds of...
I just asked you whether, given that now for the future discrimination is not permissible, you had any evidence of schemes actually upping their contributions, either from employees or from employers or both. Is there any evidence of that?
Well, I don't have...
It would be a really good point in your favour.
Well, I don't have evidence of any specific scheme taking that step, but it follows as a matter of principle that schemes are being required for the future to provide benefits which are a little more expensive than the benefits which they were providing in the past. And that will have to be funded from somewhere. It may come from employers, it may come from employees.
The background is that defined benefit schemes of this kind are disappearing fast.
So that's the real answer, isn't it?
But for new entrants are virtually unheard of now, I think. But for existing members, there might perhaps be this kind of consideration.
Yes.
Yeah.
And it will vary from scheme to scheme what the impact of that is. But if the scheme is told subsequently that it also has to pay for pensions for same-sex survivors based on service in the past, then it has what we would characterise as a new retrospective liability, which has not been catered for in the past by collecting the necessary additional contributions. And it is that retrospective effect which paragraph 18, we're concerned with in this case, is there expressly to prevent. So after December 2005, after civil partnerships came into force, pension schemes were required to cater for survivors' pensions on an equal basis for civil partners as well as for opposite-sex spouses. But Parliament decided not to give retrospective effect to the Civil Partnerships Act in this respect. So pension schemes were not required to equalise benefits, survivors' benefits, which had accrued in the past before the relevant discrimination on grounds of sexual orientation had become unlawful. Now you have paragraph 18 at MS 583, volume 2, tab 21, MS 583. And you've seen it. But it is common ground between the parties that this provision applies to Mr. Walker's claim, and indeed can't, even with the strong interpretative obligation under EU law or the Human Rights Act, be interpreted in any other way but to apply to Mr. Walker's claim. And that is because his claim is about having access to a benefit, section, paragraph 18.1, having access to a benefit the right to which accrued before the 5th of December 2005, or, in fact, which is payable, it's B, which is payable in respect of periods of service before that date. So it is common ground that Mr. Walker's survivor's pension is payable in respect of periods of service before the 5th of December 2005. Well, of course, it must be. He retired in 2003. But it is common ground that we are looking at the past. We're looking at what happened to him while he was in service. Now, Mr. Chamberlain was at pains to argue yesterday, and of course one entirely understands why he wants to argue this, that Mr. Walker's claim is not about how he was treated in the past during his period of employment, but about how he was treated subsequent to his employment when he became a civil partner, or indeed how he may be treated in the future. You recall he was asking the trustees of the scheme to guarantee him the payment of the pension in the future. Now, we say that is wrong. Mr. Chamberlain said, firstly, that Mr. Walker's claim was not about the terms on which he acquired the right to a spouse's pension during his employment, but about the failure of the trustees to confirm, some years after his employment ended, that he would be entitled to a spouse's pension on the same basis as if he was married to a woman. But the reason why the trustees didn't and wouldn't confirm that was because the scheme rules didn't provide for that while Mr. Walker was in service. And the scheme said, we don't have to go further than the legislation requires us to go, and we won't. So we come back to past service. Secondly, Mr. Chamberlain argued that Mr. Walker brings no discrimination complaint about anything that happened during his period of pensionable service, and indeed could not do so because he was not at that time married or in a civil partnership. He says he was only able to enter into a civil partnership after his employment ended, he says. Well,
do you accept that if Mr. Walker had married a woman after he retired, that she would have acquired a right?
Yes.
And that right would have accrued to her only upon marriage?
Well, upon marriage and Mr. Walker dying.
Yes, and Mr. Walker dying, yes, quite.
Yes. Yes. But, my Lord, it is certainly right that Mr. Walker had no discrimination complaint during his period of service. That's our point, because the law did not prohibit discrimination on grounds of sexual orientation at that time. The reason that Mr. Chamberlain gave for saying that he had no complaint during his period of service, we say is entirely incorrect. He said that Mr. Walker couldn't, during his employment, satisfy one of the conditions for the benefit, i.e. being married or in a civil partnership. That's why Mr. Chairman says he had no complaint. But it's simply wrong in principle to say that a complaint about exclusion from a benefit cannot be brought until the point at which you fulfil all the conditions for being paid the benefit. That can't be right. If that were right, a claim about exclusion from earning a standard retirement pension could not be brought until after you'd reached retirement age. A complaint about exclusion from entitlement to an ill health benefit could not be brought until you became ill. Indeed, if Mr. Chamberlain's argument is correct, Mr. Walker still couldn't complain about being excluded from a survivor's benefit because he hasn't yet satisfied the condition of dying. Can't be right. So he didn't have a complaint during his pensionable service because his treatment wasn't unlawful at the time, not because he only got married at a later stage. So we say the position is, as Lord Reid put it to Mr. Kavanagh yesterday, that discrimination occurs during service and not at the point subsequently at which a pensioner enters into a relationship which doesn't qualify for a survivor's pension. Now, going back to paragraph 18 for a moment, contrary to what Mr. Chamberlain said yesterday, it isn't common ground that a claim like Mr. Walker's would succeed if paragraph 18 was not there. We say if there were no express limitation on retrospective effect, that would still be the correct interpretation of the Equality Act, that it doesn't give retrospective effect in that way. Firstly, because of the English law presumption against retrospective effect, which I'll come back to in a moment. And secondly, because the Act was not intended to go further than the directive, which does not require retrospective effect. And let me make one other thing absolutely clear, because Mr. Cheney, with respect, has misrepresented our case on this important point. Our case is that the United Kingdom was entitled to permit schemes not to make retrospective changes to survivors' benefits, not that EU law required member states, including the UK, to enact restrictions on retrospective effect. Can do it, you don't have to, can do it. Member states can always go beyond the minimum content of EU law rights, and some states have done so in this context. The Irish rule in the Paris case don't have a similar restriction to paragraph 18, for example. Now, I'll come back to this point when we get to Maruco and Roma, but it is an important point. We don't say that EU law requires a restriction on retrospective effect. So before I leave the general principle that conduct should not be subsequently characterised as unlawful when it was lawful at the time that it occurred, can I just draw your attention to the two other materials in the clip that we handed up. One is the extract from Benyon, which describes how the presumption against retrospective operation works in domestic law, and 291, the final main paragraph on that page, and going over the page, first half of 292, makes this point of general principle that the law should not subsequently be changed so that people find that their behaviour has become unlawful when it was lawful at the time. And then finally in the clip, Craig and de Burker makes the same point as to what EU law requires as, or states as a matter of general principle, and that's on the first couple of pages, 558, 559 of that clip. So part two of my submissions is to seek to demonstrate that EU law arrives at the same position that conduct of the scheme trustee should not be subsequently characterised as unlawful when it was lawful at the time, and it arrives at that end point by three simple stages, and they're all stages which Mr. Kavanagh outlined to you yesterday, and I don't need to take very much time on them. The first proposition, the first stage, is that pension is pay. Just like salary, it's pay. Secondly, the right to pension, including survivor's pension, is accrued from week to week in the same way as salary. And thirdly, the EU law principles of no retroactive effect and the future effects principle regard the right to pension as one which is definitively fixed upon the relevant pensionable service and is not altered by the advent of new legislation. Now, as I say, you heard about all these things from Mr. Kavanagh. I just have a couple of footnotes really to what he said yesterday. First proposition, pension is pay. If this case was about ordinary pay, salary, there would be no doubt that the change in the law when the directive came into force could not have retrospective effect. Before the directive came into force, employers were not prohibited from paying their homosexual staff lower wages for the same work. And you have an example of that in the bundle, just for your reference. It's the Grant and South West Trains case, bundle 6, tab 79, MS 1813. This was a case about a travel concession for spouses and unmarried opposite-sex partners. Ms. Grant had a same-sex partner, so she was in the same position as Mr. Walker of being offered a benefit which was of no use to her. She had suffered sexual orientation discrimination, but it wasn't unlawful. At the time, there were a series of creative arguments as to how it was in fact sex discrimination.
I remember them well.
Yes, so do I. And the court.
So I'm just looking at the author thereof.
No, well, not in that case.
No, not in that case. But
in other cases. The answer of the court was not sex discrimination, but don't worry, sexual orientation discrimination is coming a few years down the line. We have the Treaty of Amsterdam. On the coming into force of the directive implemented into domestic law, then that practice of paying your homosexual staff less for the same work had to stop. But nobody would suggest that a homosexual employee could bring a claim for the salary differential over a period prior to the change in the law, or that Miss Grant, for example, could claim for the travel concessions that she hadn't received in the past before the law changed. That would be to hold the employer liable for conduct which was lawful at the time when it occurred. Nobody would say that was right. The EAT in paragraph 1, MS 3078, gave the example of the woman's wages example, as Mr. Justice Langstaff put it, but that's the same point. And pension is pay just as salary is pay. We know from the Court of Justice case law cited by Mr. Kavanagh, we know that is the basis on which the directive is said to apply in this case, Article 3, discrimination in relation to pay. Mr. Walker accepts, of course, that there could be no retrospective claim for salary once the directive comes into force, but he can't suggest, we say, a principle which distinguishes pension from other types of pay. Second principle, second stage, the right to pension is accrued from week to week, just like salary, with salary. And that's 10 over, Advocate General, paragraph 17 and 19 that you saw yesterday, and also as applied to survivors' pensions, paragraph 49 of the Advocate General on MS 474. And it's also how domestic law regards the position, the Kapoor case you also saw yesterday, tab 2, bundle 2, tab 30, MS 651. We've set out the paragraphs in our printed case. Thirdly, then, the future effects principle. This is the principle which, as we know, the Court of Justice applies when determining the effect of new legislation on pre-existing legal relationships. It's outlined by the Court of Appeal in paragraph 5, MS 3055. As Mr. Kavanagh submitted, it's clear from Tenover that the right to pension becomes definitively established upon the relevant service being undertaken by the employee, paragraph 19 of the Advocate General. As he also submitted, the Court technically in Tenover is addressing a different question, but similar issues, similar language, the reasoning on the point is directly transferable. In the context of the Innospec scheme, Mr. Walker accrued year by year a right to an annual pension worth, as it happens, 1/57th of his final salary, and amongst other benefits, a spouse's pension based on his own annual pension should he die leaving behind a wife. Those were definitive rights which were protected by statute, as I've shown you. They could not be taken away from him. And Mr. Chamberlain said today, to say that Mr. Walker's pension rights were definitively fixed is to presuppose the very question at issue in this case. To the extent that I understand that submission, I say no, it's not. It's to answer the question. The question is the right in question definitively fixed? Is a right to a pension accrued week by week definitively fixed upon service? Answer, yes, it most definitely is. Now, if it's not, if the right to a pension is not fixed upon the relevant service being undertaken, the only possible alternative is the alternative that's given by Mr. Allen in the Miller case, and he says that the right is definitively fixed upon retirement. Now, we disagree with that for the reasons given by Mr. Kavanagh, but even if that's correct, it doesn't help Mr. Walker, because Mr. Walker retired before the directive came into force. He was definitively fixed on Mr. Allen's analysis before the directive. Now, it is for these reasons that you have heard scarcely anything at all about the future effects principle from Mr. Chamberlain. It is not territory on which his claim can succeed. Simple as that. Where he focuses at the beginning, middle, and end of his submissions is the three cases that we're going to come to, and I will turn to them. But it is telling in my submission that he simply has no answer to the Court of Appeal's analysis as to how the future effects principle, which is the right test, how that applies in this context. Before I turn to the cases, can I just make one? Can I give you one reference by way of footnote to Mr. Kavanagh's submissions? The 1986 Occupational Pensions Equal Treatment Directive, Bundle 2, Tab 17, MS 553, Article 8, is an example pre-Barber, so not in the Barber line of cases, where the EU legislature has specifically said in addressing occupational pensions that the change in the law need not apply to pension service before the directive comes into force. Mr. Allen said there was no such example. There's no example outside the sphere of Barber. In fact, there is.
Article
8.
Thank you.
Now, the trilogy of cases, it's part 3 of my submissions. The starting point is the Court of Appeal, paragraph 35, MS 3063, and paragraph 60, 3069. and the starting point, which is essentially where I've got to, the future effects principle is plainly in our favour. That starting point could only be displaced by clear statements, we say, in the judgments of the Court of Justice. And we say that no such statements are to be found in Maruco and Roma, which address different questions on different facts and did not discuss the issue that we are concerned with. The Maruco case, then, Bundle 1, tab 7, this case concerned, as the court may have picked up, a pension scheme which is really far more interesting than the Innospec scheme. It's part of the legacy of the Hitler government. As you'll see at page 280, paragraph 15, the scheme originates in a collective agreement of 1937, established under the Reich, and in subparagraph 2 of the provisions set out, the job is given to the Minister for Popular Enlightenment and Propaganda to appoint the insuring institution, set out the insurance conditions. And you see in subparagraph 3 the range of persons who are deemed to be within the Reich Chamber of Culture. They include not just the actors, directors and producers, but the chorus members, dancers and hairdressers, and perhaps shows the high esteem with which theatre professionals were held in the Weimar Republic.
I think it's somewhat later. It's after that. I think we're talking about Dr. Goebbels.
We're talking about National Socialism. It's exactly what it is.
The Minister for Propaganda in 1937.
They continue to be held in the high esteem in which they had been held in the Weimar Republic. Put it that way. The legally interesting aspects of the pension scheme are threefold in my submission. The first, go over the page, MS 281, letter D, is the rule, and it's set out in domestic regulations, the rule that the widow's pension is payable to a spouse of the insured man or retired man if the marriage subsists on the day of the latter's death. So no right under the domestic German provisions to a same-sex partner's pension. That's the first aspect. Second aspect, 270, MS 270. Paragraph 70, letter C, the Advocate General tells us that theatre professionals were compulsorily affiliated to the scheme while they were employed, but voluntary affiliation was also permitted owing to the precariousness and lack of employment continuity. And indeed, for more than 16 years, Mr. Maruco's partner had been voluntarily affiliated and paid the contributions. That's the second aspect. The third interesting aspect we say is in the next paragraph, which tells you how the pension was funded. And you see that there was a funded system, as the Advocate General called it, where a separate fund is set up for each insured person from which the principal and interest are used after the period of employment has ceased. The amount of the pension is calculated on the basis of the amount of the contributions by applying a readjustment factor. So this is a pension, and I entirely disagree with the way that Mr. Chamberlain characterised it this morning. This is a pension which is not based on years of service, nor is it based on final salary or indeed average salary. What it's based on is the pot which each individual member has after making his contributions over the years. And it is, as we submitted in our printed case, far closer to what we would regard in this country as a defined contribution scheme, not a not a defined benefit scheme such as the Barber case law was concerned to deal with. But I'll come back to that. The fifth question, page 289. It's paragraph 74. Well, what was the question? Both Mr. Allen and Mr. Chamberlain have sought to suggest that the court thought it was being asked more than just whether Barber applies in this particular context. And we say that is not correct. Paragraph 32 on 283 that Mr. Chamberlain in fact took you to this morning makes very clear that the domestic court thought it was asking, and the Court of Justice perceived it as being asked only about Barber. Now, why was that question asked? Many legal minds have speculated about that. Paragraph 32 on 283 one can see some of the reasoning of the referring court. Says this is the bits of national law that we're concerned with, the pensions regulations fall under Article 141, and we know from Barber that if it's under Article 141, claims only after 17th of May 1990. So the referring court felt, and to put it in simple terms, this looks a bit like Barber.
Well, I just pause for a moment. It's Article 119, which provides for equal pay, isn't it?
Yes.
So to the extent that you have the pensions equal pay proposition,
Yes.
the case does depend, or at least has something to do with Article 119.
Yes.
But was it generally right for the referring court to say that this was really proceedings under Article 119?
No, it was entirely wrong to say that.
Yeah.
It's a directive.
Yes, indeed.
I mean, 119 is that men and women receive
exactly.
equal pay for equal work. The whole point of Barber is that eliminating sex discrimination was going to cost a fortune.
Yes.
Here we're dealing with a different kind of discrimination.
Well, look, there are many reasons why this was a thoroughly bad question, and you've identified some of them just.
The trouble is, it's not so much the question as the answer, which is the problem, isn't it?
Well, my lord, the answer was entirely right. And having been asked that thoroughly bad question, and it was thoroughly bad not just because this is sexual orientation, not sex, but also we say because this pension scheme was not within the mischief of Barber at all. It wasn't a final salary scheme where you're looking at paying for pension due to service accrued in the past. But the submission of the pension scheme at 75 on MS 289, we say really summed it up. The pension scheme said, well, don't be ridiculous. How could the law go back to May 1990? This is about the directive, and the directive comes into force in 2003. Absolutely right, and that is the effect of the court's judgment. There is no Barber limitation. The court says this directive comes into force when it comes into force. Now, is the answer given by the court in paragraph 77 to 79, which is exactly the right answer? It's not a Barber case, no need to restrict the effects of the judgment in time. Is that answer of any assistance to you in deciding the question which arises in our case? In my submission, not, for three reasons. Firstly, the question asked of the court and the answer which it gave were about the Barber limitation. Now, Mr. Allen and Mr. Chamberlain spent quite a bit of time in their written cases trying to persuade you that the Barber case law was nothing at all to do with the future effects principle. Here, However, it's argued that an answer of the court on Barber, and a wholly correct answer, tells you everything you need to know about the future effects principle. That can't be right. Secondly, the facts of the case simply did not raise the issues that we have in our case. The pension rights in Morocco were not based on a period of pensionable service, as I've shown you, but on the size of the pot. And they weren't based on service for the further reason that you didn't even have to be an employee for all of the time that you contributed. Simply not based on pensionable service. And that matters because Barber is about paying pensions in the future for pensionable service accrued in the past. Simply not what's happening here. So there was no question in this case, in Morocco, of forcing a pension scheme to pay for periods of service during which the employee was lawfully treated. No question at all. All that was happening was there was a pot of money which had built up over the years to which the employee was entitled, and the only question was whether that pot should also be able to go to his same-sex survivor. There was no issue of making unlawful conduct which was lawful at the time. If this benefit was claimed under a similar pension scheme in this country, paragraph 18 would have absolutely no application. It's not about, it isn't a benefit which accrued through periods of service in the past. And of course, there was no argument at all about retrospectivity such as we have in our case. There's no evidence, no mention of any equivalent in German law to paragraph 18, either in the pension scheme or in the prevailing law as a whole. Nothing to limit retrospective effect, and the German court so decided, as Mr. Chamberlain showed you this morning. And we say it's unsurprising against that background that there's simply no discussion of the issues that we have in our case. Now, other points raised by Mr. Chamberlain, he says the court's ruling in paragraph 79 would make no sense. That's the no need to restrict judgment in the effect of the judgment in time would make no sense if we were right, because EU law already imposed a much greater restriction, a much more severe restriction than that which the court was addressing. Well, that comes back to his mischaracterization of our case. We don't say that EU law imposes that restriction. And it appears that what we say EU law does is it permits a member state to impose that restriction if it wishes to do so. And it appears that Germany didn't so wish.
What was the Commission then saying at paragraph F? They seem to have thought that the sort of timing of the directive was a relevant factor.
Well, the Commission at 76 is addressing the Barber point, how much financial damage would be caused by the ruling of the court in this case, and the ruling of the court is the ruling which allows same-sex partners in Germany to claim equality.
They're not saying a bit more than that. They're referring to a directive, but the directive doesn't contain any transitional provisions. It simply expects the principle of non-discrimination to be given effect, or requires that principle to be given effect in the law of the member states from a given date.
Yes.
And paragraph 18 effectively is a transitional provision which derogates from that general principle. That's one way of looking at it.
Well, that's one way of looking at it. Of course, the question is when you say that the directive requires that it comes into force immediately. Yes, from 2003. Well, the question is then, well, what does that mean in respect of things that have happened in the past? And my submission, as you know, is that it doesn't require states, for all the reasons that we see in the sex discrimination case law, it doesn't require states to retrospectively equalise pensions.
Would that be a convenient moment?
Yes, I think I'm just about to move on to Roma.
Well, we look forward to hearing from you further at 2:00.